What is up, gang? Welcome back to the channel and welcome to the second episode of the Weekly Reaper. I'm testing out a couple new things. Check out this sweet little background we got going on. I am trying out a little mobile workstation situation. Got a new little mic, plugs into the laptop because I might be traveling soon and need a little remote setup. So we're going to see how this goes, but I like this. I like that. Got a little green screen action going on. This was a busy week, you guys. This was a busy week. A lot of stuff happened. Got a lot of stuff to go over. Much of it has been covered, thoroughly through everybody's YouTube channels and the press and tweets and everything. But we're just going to do a little quick overview of everything that went down, and starting out with Ben's sassy clapbacks to the motion to dismiss. I mean, the footnotes in this thing are amazing. Since everybody kind of covered this, Laura covered it, Tug, everybody, I'm just going to be going over the footnotes because that's where the sass is, and that's what we want to see. So here we go. Number one, Ms. Heard's assertion that Mr. Depp made no attempt to limit his damages to the time period preceding the UK judgment is simply false. The testimony elicited from Mr. Wig and Mr. Depp's damages experts were all limited to the period between publication of the op-ed and the date of the UK judgment. Moreover, the jury instructions expressly limited the time period for which Mr. Depp could recover damages, stating both that Mr. Depp cannot recover damages for any harm that occurred after November 2nd, 2020, and that any damages must have been caused by the defamatory statements at issue. Juries are presumed to follow their instructions, and there is no reason to believe the jury did not follow the instructions in this case. End of story. There's no reason to believe they didn't follow the instructions. Number two, Ms. Heard argues here that the $10 million in compensatory damages awarded was intended to punish her. But that's clearly not the case. It's the $5 million in punitive damages that's the punishment to Ms. Heard for her actions, not the $10 million in compensatory damages, which reasonably reflects the damage attributed to the op-ed between December of 2018 and November 2nd, 2020. Yes, it was made abundantly clear that Johnny actually lost a ton more money than that. Just going off of Pirates alone was $25 million. And if you look at everything else, the Houdini project was mentioned, and God knows what else he would have done with Disney. 10 million is like nothing actually in the scheme of what he lost, not to mention all these ridiculous lawyer fees and everything that are going to be in the millions of dollars for this suit. Also, the 5 million in punitive damages was, of course, properly reduced to the statutory cap of 350,000. Yes. Number three. Furthermore, Ms. Heard waived any objection to the contents of Mr. Depp's opening and closing statements, as well as questions posed and testimony regarding historical events, by failing to timely object at the time. What a shocker. She was late. This is like through the whole case. Look at everything that happened with the phones, with the metadata, with handing over her stuff. She was late. It's the same thing as with the juror number 15. She didn't bring it up during the trial. She tried to save that for some kind of bomb afterwards for this appeal and just got nuked. Motion for mistrial is untimely and properly refused when it is made after the jury has retired. Done. The jury retired a month ago. Get out of here. You're done. It's over. Number four. To the extent Ms. Heard invokes the non-binding law of other jurisdictions where defamation by implication of a public figure is only permissible when the inference arises from the omission of material facts in the challenge communication, such a standard would still be unavailing for Ms. Heard, who failed to disclose the material fact that she was not abused. End of discussion. Boom. Failed to disclose the material fact that she was not abused. Ben Bomb. That's some sass. We love to see it. This one's pretty fun. For instance, Ms. Heard cites a recording of Mr. Depp discussing purportedly headbutting Ms. Heard while admitting to disclose to the court that Mr. Depp clearly testified that he did not deliberately headbutt Ms. Heard, but that their heads collided on one occasion when she physically attacked him. People go on and on and on about this damn recording of the accidental headbutt. Well, lucky for us, we have the perfect example of an accidental headbutt, thanks to Johnny over the last week with Jeff Beck. Ta-da. Boom. Oops. Sorry, bro. One more time. Here you go. Plunk. Voila. Accidental headbutt. Do you love when that happens? All right, so moving right along through the week, shortly after Ben came back with the epic clapbacks, in his reply, Judge Penney, for the win, denied everything. Here we are. After review of defendant's post-trial motions, plaintiff's opposition, and the relevant statutes and case law, it is therefore ordered as follows. Defendant Amber Laura Heard's post-trial motions 1 through 6 are denied for the reasons stated on the record. The purpose of voir dire is to obtain a fair and impartial jury. Voir dire is necessary to ascertain whether any jury has any interest in the case or any bias or prejudice in relation to it, and that he, in fact, stands indifferent in the cause. The summons issued to Juror 15 listed his legal name and address, and no birth date was noted. The court has pulled Juror 15's jury questionnaire, attached as redacted and filed under seal. Juror 15 completed the jury questionnaire as himself, filling in the proper birth date. The information presented on the jury questionnaire matches the information Juror 15 provided to the court. Juror 15 was vetted by the court and on the record and met the statutory requirements for service. The parties also questioned the jury panel for a full day and informed the court that the jury panel was acceptable. Therefore, due process was guaranteed and provided to all parties in this litigation. Voir dire was conducted in a fair and impartial manner. This is what we've been saying the whole time. Her team agreed to these jurors just as Johnny's team did. Everybody sat the jury. Both teams had ample opportunity to object and to choose other people, and they both settled on the jurors that they chose. Therefore, they all agreed that this gentleman was going to be unbiased and listen to the case in full and make an informed decision. End of story. There is no evidence of fraud or wrongdoing. Further, the defendant was provided the jury list 5 days prior to the commencement of trial and knew or should have known about the mistake at any time during the 7-week pendency of this trial. She had every opportunity to object to or to voir dire on the issue. Parties generally must make objections at the time a ruling or order is made to put the court on notice that an issue is meant to be preserved. Despite defendant's assertion in footnote 9 of her motion, clearly states any error in the information shown on such copy of the jury panel shall not be grounds for a mistrial or assignable as error on appeal, and the parties in the case shall be responsible for verifying the accuracy of such information. Here's the main issue. Amber never takes responsibility for anything. Now, if you ask me, they held this in their pocket for this reason, because they knew they were going to lose. There's no way you win this case. There's no way that they should have won in the UK. Not that they did. It was the Sun. I know. But they held this in their pocket for an appeal. They knew. There's no way on this green earth you're going to convince me that they didn't know that there was this little error going on or whatever. Or maybe they just made it up after the fact to make a run at something. Anything's possible. But there is no time ever that Amber takes responsibility for anything. So of course, this is not her fault. Oh, they didn't know. Oh, the guy's birth date is 1945 or whatever the hell it said. Nah. Good for Judge Penney. Consequently, defendant, as well as plaintiff, had an affirmative obligation to ensure the accuracy of the information provided for the jury panel. A party cannot wait until receiving an adverse verdict to object for the first time on an issue known since the beginning of the trial. The issue has been waived. Exactly. Can't just decide once you lose the trial, wait, this guy, I mean, we knew from the beginning that his birthday might be wrong, but now we lost. So this guy shouldn't have been on the jury. Get out of here with that. Even if the objection has not been waived, objections to any alleged discrepancies in jury lists and any legal disabilities of potential jurors must be made in accordance with Virginia Code Section 801352. That section provides in relevant part, unless objection to such irregularity or disability is made pursuant to subsection A herein, and unless it appears that the irregularity was intentional or that the irregularity or disability be such as to probable cause injustice in a civil case to the party making the objection, then such irregularity or disability shall not be cause for summoning a new panel or jury or for setting aside the verdict or granting a new trial. There it is in black and white. Also, if they had an issue during the trial, there were alternates. Remember, 2 people got dismissed at the very end before they went to deliberations. If you had this issue during the trial where you thought that the guy's birthday was messed up, you had alternates to choose from to take his place. No, they saved this in their back pocket to make a run at this ridiculous appeal. Furthermore, while parties must make this objection while following the above procedure, the party moving under this code section must provide some evidence of prejudice. Defendant has neither followed the proper procedure nor shown evidence of prejudice. Oh, what a shocker. She didn't follow proper procedure and didn't show any evidence. What a freaking surprise. Like, what else is new? No evidence and didn't follow procedure. Shocking. Defendant does not allege Juror 15's inclusion on the jury prejudiced her in any way because it didn't. The juror was vetted, sat for the entire jury, deliberated, and reached a verdict. Exactly. The only evidence before this court is that this juror and all jurors followed their oaths, the court's instructions and orders. This court is bound by the competent decision of the jury. Entered this 13th day of July, 2022. Signed by Judge Penney. This order is final. She's got to be so done with them. I cannot even begin to imagine how done she is with Elaine and that whole clown car. My God. Oh, what a shit show. So, in addition to her denying all of Amber's motions to just say, throw the verdict out and say that I win because I feel like it, Judge Penney dropped another bomb, which is she has ordered the unsealing of a ton of documents. Most of these are motions. There appears to be some evidence attached to some of them, but most of these are motions made by either side that for some reason were filed under seal. And during the trial, or at the very end of the trial, Penney made a comment wondering as to why all of these things were still sealed, especially in light of the trial having taken place. So this is going to get hopefully very interesting. It'll be interesting to read through these. I have not seen where they are available yet, but when they come through or when access is granted to them through the website or in whatever type of way, we will definitely be going through all these. I'm sure that'll be a huge podcast episode or several. But a lot of this looks very interesting. Dr. Curry's personal medical evaluation attached to plaintiff's designation, ID of expert witnesses. She wanted the IME completely thrown out. If you recall, it looks like the motions in limine are going to be unsealed, which will be great to see what didn't get in. So a lot of stuff here, and that'll be fun to dig through when the time comes. All right. The next thing that we're going to look at is a little bit more on the insurance lawsuit front. Earlier in the week, I did a video with the actual complaint of the New York Marine Insurance Company that is suing Amber directly in federal court in California. In addition to that, Travelers Insurance is suing New York Marine. And there's a whole cluster going on here that I do not begin to understand quite yet in full. But what we have from this week is that both cases were transferred from one judge to the judge that is handling the New York Marine case, and now both lawsuits are under the same judge. So I think that this is going to get really interesting. First of all, Amber's now in a fight with an insurance company. She's being sued by an insurance company, which is not somewhere that you want to be because they will not give up and they're not going to let it go. So whatever's going on here, it's not going to be easy for her to get out of or weasel around. In addition to that, Laura had a really interesting tweet, which is that there is seriously something fishy with Travelers Insurance, Pamela Johnson, and Amber Heard, and $8 million in legal fees for her defense with a $500,000 liability cap, exclusions for knowledge of falsity, 4 law firms, yet more lawsuits. What could you possibly claw back? This is interesting. It does appear that there are more companies getting involved. I don't really know what to make of all this. And this is something, if they only have a $500,000 liability cap, how do you accept paying $8 million in legal fees? And the New York Marine Company only had $1 million liability cap. Of course, now everyone's trying to get out of it because she lost and they're saying that they're not liable. But this does actually get more interesting. Okay, so there's another tweet here. Keep this traveler's insurance in mind. This is from this morning. Do I remember correctly that Vanguard Group was one of the funds used by Musk to siphon money to the ACLU in Amber's name? Well, guess who's the number one shareholder of Travelers Insurance? Very interesting indeed. So, check this out. Boom. Top 10 owners of Travelers Companies, Inc. Number one, the Vanguard Group with an 8.58% stake and over 20,000 shares, almost 21,000. That's interesting. The musky part of this story might not quite be over yet. Definitely something to keep in mind. It's funny. I was talking with somebody the other day and saying that I was surprised that her claim that insurance was paying for her legal fees turned out to be true, because almost nothing she says is ever true. So I was surprised that turned out to be true. And then we sort of had this conversation and settled on the fact that Elon probably taught her how to use the homeowner's insurance to take care of her liabilities, to pay for her defense. And now we sort of have these little nuggets falling that Vanguard is the top shareholder of Travelers, and that they own this 8.5% stake in the company. I mean, nothing is coincidence in this shit show, it's just not. Very interesting. Very, very interesting. Definitely worth keeping an eye on those insurance lawsuits and see what comes out of there. Oh boy. The next thing we're going to talk about is the never-ending saga. That's the failure of the press. They're just failures, absolute failures. So NBC decides that they are going to do this ridiculous, I suppose we're going to call it a documentary, if that's what they want. Okay. So this aired last night at 10:30 p.m. Eastern. Okay. Couple things here. 10:30 p.m. is not prime time. That's like well after hours. That tells me that they knew that this was hot garbage, was not going to go well. So this aired yesterday. Tonight at 10:30 p.m. Eastern, NBC News examines how the Depp v. Heard defamation trial evolved into, quote, the TikTok trial, and what the verdict means for victims of domestic abuse. Watch A Marriage on Trial live at blah, blah, blah. Nobody's watching that. Nobody did watch it. It was hot garbage. I didn't even know that this was happening until this morning, and it already happened last night. 10:30 they aired this thing. They didn't expect anything. And the absolute ratio on this is amazing. Look at this. 34 likes, 179 comments. They got obliterated. And I'm sure it's still going this morning. These people, you guys, like, you're just failing miserably. That they just cannot get off this damn horse. They cannot admit that they were wrong. It's so incredible. And instead of just like shutting up, like, okay, you don't want to admit that you're wrong, right? And so you don't want to say, oh my God, Johnny was actually the victim and we were so wrong. We have to recant and repent and all this. Just be quiet. Instead of trying to continue to force feed people this absolute nonsense, where you try to twist her into still being any sort of victim in this situation, just be quiet, because you're just going to continue to get obliterated. Nobody wants to hear this. People watched the trial. Millions and millions and millions of people watched the trial. The fact that they keep on trying to rewrite this thing in the media is just an absolute insult to the intelligence of the population at large. People watched. They know what happened. They saw her take the stand. She tanked her own case when she took the stand with all this gobbledygook nonsense for which there was no evidence. People want to talk about what this means for victims of domestic abuse. Don't lie. She's the one who made this a problem. She made all this crap up, presented absolutely nothing to verify her claims. And what she claimed was horrific, 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 gruesome, absolutely physically altering what would have been physically altering levels of violence. And there was nothing to account for those claims. Okay. She's the one who hurt victims. And these people with this continuing rhetoric are the ones who are continuing to hurt victims and continuing to hurt Johnny, who is the victim. But none of these people are ever going to look at it from that point of view, because women. Well, what you need to do is hold everyone accountable for the things that they do. Let's take a look at a couple of tweets here. Kind of in the same vein. This stupid person. This is the perfect articulation of what so many DV victims felt watching this unfold, yet couldn't quite put into words as the overwhelming support for Depp flooded our timelines. Yes, because people were watching the trial and it was extremely obvious that he was the victim and she was lying through her teeth. Okay. These people didn't watch the trial. Even if they did, they don't care. None of these blue ticks care. And it's so infuriating to watch them get this stupid platform that they've got going here. So we have this Kat Tenbridge person. She's so excited to be in the documentary, right? Featured interviews in A Marriage on Trial, Johnny Depp, Amber Heard, Truth in the Age of Social Media include Heard's attorney, Elaine. Elaine is featured in this nonsense, okay? National Coalition Against TV CEO Ruth Glenn, American University law professor, and gender violence expert Jamie Abrams. Did any of you watch the trial? I just want to know if any of these people watched the trial. I'm not even sure Elaine watched the trial, let's be honest. NBC News tech and culture reporter Kat Tenbridge. What could you possibly add to this? News tech and culture reporter and some guy from People magazine, Nigel Smith. It's just ridiculous. Everything's ridiculous. And you have this person who I scrolled by already. Jurors have none of this training and are simply part of our society. All those myths the culture responds with, jurors are part of that culture too, and they often have access to less information because of evidentiary rules. Yes, they can get it wrong. Okay, let's talk about something for a moment. All right. The jury is specifically chosen to not have expertise in any of these fields. When you go through the voir dire process, they weed out medical professionals, law professionals, anybody who has a connection to LEO or is LEO, law enforcement officers. They don't want people who can use their career track to influence the rest of the members of the jury. I have seen this argument so many times about, the jury they don't have expertise in DV or this, that, and the other thing. They're not supposed to. They were specifically weeded out. They wanted regular people with regular jobs who don't know anything about the parties, the case that's about to take place, the contents of the case, meaning obviously violence and personal injury, etc. They just want regular people. So this argument is moot because it doesn't exist. This argument doesn't exist. You're not going to have a jury that's an expert in whatever the case is ever. Lawyers specifically do not want those people. If you have a medical malpractice suit, you're not going to have doctors on the jury. That's how it goes. When I sat for jury duty here in LA about a year ago, they specifically weeded out everyone in law enforcement, everyone, the exact same thing, because it was a domestic violence trial. Anybody with medical training, anybody with legal training, all that. They just want regular people who can understand facts as presented and make an informed decision. These people drive me nuts. This is like, I'm so beyond over these hot garbage takes. I can't begin to tell you, because you go on Twitter and you pontificate like this and you think you're making a point and you get all of these people riled up and they like your tweets. Yeah. Why wasn't the jury experts? Well, because they weren't supposed to be. Specifically chosen not as experts. That's why there are expert witnesses from either side that present the case for the party that they are working for. All right. And the jury decides who is more credible in order to make the decision at the end, which is Amber got railroaded because she tanked her own case. End of fucking discussion. So tired of these people. It's infuriating. Everything's a failure. The press is just an absolute failure. I hope that one day there is a real documentary made, that presents everything I mean, I'm sure it won't put it to rest because people will scream forever about this with the feminism and the blah, blah, blah. You're just doing more and more harm to the people that you're purporting to represent because this person, Amber, is not the savior of the female species here. So that's sort of my rant. Thanks for listening. A couple other things to wrap up. The Brooks case settled. There are some documents floating around. I didn't grab them. Sorry, but there's no details. It's just sort of a court order signed that a settlement has been reached, and so that trial is off the books. And tomorrow, the Jeff Beck album comes out. So make sure you grab that if you can. Like I said on the last video, a lot of the songs have been dropping as singles over the last few weeks. So don't forget to check that out. And yeah, that's going to be it for this week. Thank you guys for tuning in. Thanks for listening. Thanks for watching. Brian and I will hopefully be back with another regular long podcast or a live either this weekend or sometime next week. He's been traveling. As you know, he came to visit me last weekend, which was awesome. We had a great time. He might stop back by here before he heads home. So if that happens, we'll try to get a live in this time. But thank you guys so much. Thanks for your support. Thanks for listening. Thanks for watching. And I will see you in the next one. Bye.